For me, it is a proper conviction. Nobody is saying that it's not a proper conviction. But she also has a lot of rights under the law to explore. If she decides to explore those rights, nobody should have issues with her. So the state will never shield her. Let me emphasize. For any reason, she has to serve a sentence. If
Mama was saying, I'm a quaba, Mr. Say, Obas, what was scrappy, Eddie, Mamma, like video in a shame on you, so when you be envy. Your mamma Sedina Tamakloe'S, Nasamia air cosby. Bernard Bediako Baidoo, our year a member of parliament, what tonable, actually in Semunu. Na mi tie man no na na me ka sese ni pese o ye teacher na so wo kire wade e wo classroom na so wan ti saade no asia na kire se wan kasa na ebia na wuti enye adwuma enti asam no mempo di na menim sese woman no owo America ho nyina na asam no e da so e wo court because Ghana mra e kire sese ye dobi e ko court na se ye convict nipa no owo 3 months se wo de be apiri enti se 3 months no etwem na se wan apiri dia na kire se saa akwanya no abonipa no na se emra na maame no owo ho no 3 months no endru na no lawyers e call for appeal enti asam no e da so e wo court enti sie ya convict maame ya yesan so e de no abagan na se o me face the loss of the land no akwatia MP ama yati ase se asam no e wo court dada enti that appeal no afi na ye ba be kan sa asam no enu nti maame no be ko akokugina court basisi ya me no e kasa die police for Afreno, it was police for Akachi, it Bernard Bediako Baidoo, a tonebo actually as some na. Now, way and na Roland, our year host, all beside say, Profobinum Eka, say, or politician, now we sign so a NDC, na NDC, a what power idea, Abia, His Excellency Dramani Mahama, obey to me, I'm an presidential pardon, and I say, Abia, there will be some kind of influence somewhere, a year from. Above, a bit me a siana, Bernard Bediako Baidoo, was a bit me the Nessa Esnebo. I can't actually Ghana for say, His Excellency Dramani Mahama, or no dear, or so in someone said be a year in some papa so. Mameno will say Ako court, say sign any Nasam Lubium, say any Nasamono, Massa Samono, Ebu Bonne dear, or Neganamra, Ebeko Aquidi, but say a biana Samono a day, not say court no, a cast yin dear. Na enye His Excellency Dramani Mahama ena waka se yenyaro na emom sene asem no esi etie no judge na obetna agwam na watie asem no ena wabua asem no enti ekoba saa ema obia enye na bi se His Excellency Dramani Mahama ena ebia wanyimfunu wense na saa tumi no kura se owo se obetimi aye saa kura onye egum se ebia obetimi aye but onye enu nti no obia enyi saa adwen no empa infri ni trim because the woman where Ghanaian and no one in Ghana here is above the law. So when the assembly enya, the laws of the land will deal with her. But senasem so the nasa court to see nyano dia to me say mine. Now I can say ebia court no still na ovano entum. Me say umle my young kutie honorable Bernard Bediako Baidoo akwatia MP. Nasema waka ediafa Sedina Tamakloe'S Nasumia Ekosi eho nansa na bibi video mesro se unya unsubscribe ya na subscribe e dia ma like video we na share ma uni no nso unya bi ewe beda wase yakoba ye beto waso.
We've come to the point where now the public opinion is that we're going to have the president some point in time in serving her sentence offer her some prerogative of mercy by giving her clemency. You think that's far-fetched? That's very preemptive.
Good morning to you and my senior brothers here, as well as your viewers. To the people of Ghana, to His Excellency, we thank God for bringing him back to continue with the work he's been doing. You see, I'm not too sure where this is coming from, and I would not join in speaking about it because I think that I don't have any evidence to the effect that there is even such a position being contemplated by His Excellency. Not at all. I mean, I don't think. But you see, let me say a few things. I think that it will serve a very great purpose this morning to bring certain things to light.
For clarity.
For clarity.
Okay.
First and foremost, Do you know that there is a pending appeal in this matter?
There is?
Yes, there is. There is a pending appeal in this matter. I'll come to the matter proper. Now, the appeal, when, you know, in our criminal jurisprudence, the right to appeal is within 3 months after conviction. And then with the leave of the court, another 3 months. So put together 6 months. Now, so the 6 months, of course, has elapsed. It doesn't necessarily shut the door, but in that case, you have to file a special process for extension of time to appeal. This is tried with lawyers as practitioners. Okay. Do you understand? So their lawyers, her lawyers did that and got the court to grant them that leave to appeal. As at the 12th day of February 2026, they had filed their submissions, written submission. I have a copy here, about 78 page.
Wow.
Yes, it's been filed. These things must be brought to the fore so people know. And it's within her right. It's a legal remedy available to her, especially, Roland, as she was tried in absentia. That point must be made. That she wasn't heard after a prima facie case was established against her. In fact, the trial started, I think she was charged sometime on the 30th day of January 2019. As at the 10th day of January 2022, she wasn't in court. That was the first time she wasn't in court. So between the 30th day of January 2019 to the 10th day of January 2022, she was always in court. That point must also be made.
Up to 2022.
22. Because the case traveled from 2019 to 2024. It was in 2022 that she did not appear in court as of January. And her lawyer, I think the former bar president in the Greater Accra region, Jakpasu. What happened on the day was that the court requested her presence, and let me also tell you what happened. She had been granted bail, admitted to bail, and she sought leave of the court to travel outside. She didn't run, and that point must also be made clear.
For medical,
you know all this, and we have to put the matters in the proper perspective. So she went on this medical, the court granted that leave, and she left. So after she left, what we do not know is what happened within the period. How much time she needed. So at some point, the court, of course, did not have information. The court requested of her lawyers to provide information about her medical status, and her lawyers were not too sure. Her lawyers couldn't, let me put it bluntly, provide exactly what the issues were. And so the court, the state, through the Attorney General, requested for her to be tried in absentia, and the court granted it. These are all the legally accepted procedure, and so there is nothing wrong with it. So she was then tried in absentia. So all the accusations that were put before her, but let me also state that the fact that you are tried in absentia, lawyers know this, doesn't mean your lawyers can't be there. So if you are tried in absentia, your lawyers can still be there and advance.
I want to ask that, yeah.
Yes, your lawyers can be there. It happens. So her lawyers were there, but the only challenge is that after the determination of a prima facie case, when the state had conducted its case and was done, a determination of whether there is a case for her to answer came up. Their lawyers were of the view that the state had not been able to prosecute the matter, but the court disagreed. So she was called upon to open her defense, and she wasn't available. So that is why we say that she wasn't heard. Not because the court didn't allow her, but she wasn't available to be heard. Now, this is it. After she was not heard, a determination was made. Let me also state that there were 78 counts, not 4. 78. We don't have time for me to go through all that.
He was not reading the counts.
Okay.
He was only
no problem. But the 78. For instance, let me just one. We are told by the state that there was this 1.5 million that Maslow gave to a certain company or Batampa. Now up for business, whatever, as loan. Then that's what the state is saying. Madam Sedina also advanced a further 500,000 through Maslow to them, but gave some conditions. That's what the state is saying, that in terms of the interest rate and all that. Now, what we are hearing is that the Obatampa people thought that the rate was too high in terms of the what do you call it, the interest. So they returned the money. But we are told that Madam Sedinam said no, it should be in cash. It should be in cash rather than the check.
That's put before the court.
Put before the court. And therefore, they are saying that their investigations refute.
According to what the facts.
Yes. So according to, no, see, the fact as I've read, states that she refused to take the check and took cash.
Yes.
They are saying that their investigations prove that 500,000 was never reflected in the accounts of Maslow. So that is what they conclude, that on the basis of that, she took the cash. That's stealing if it happened. Good. In a matter like this, I personally think that she should be heard. She should be heard.
That's your personal position.
My personal position. She should tell us what happened.
But the prosecution did adduce evidence to that effect.
The evidence of her taking the money?
There was receipts.
There was receipt of payment. But where the money was kept or who took the money, of course, there was no evidence to that. I followed this matter. But I'm saying that.
We all did, yeah.
Yeah, so I'm saying that she should be granted that hearing. Where is the money? But you see, it's not the court's fault. Let me emphasize that. You were also given an opportunity. You were not there.
We have a court of competent jurisdiction.
Yes.
And based on what the prosecution presented itself,
yes,
and then also the defense counsels as well.
The defense counsel, let me help you. The defense counsel only cross-examined. They didn't put across the case of Sedina. They couldn't have, because it's a criminal matter. She should be heard. They couldn't have. It's not a civil matter. Let's educate our viewers. In fact, in a civil matter, when the judgment is like that, nobody is disputing the judgment. In a civil matter, this judgment could be set aside. In a civil matter, for lack of hearing or for not grant. Look, that is the first principle of law. The odi otrem partem rule. You must be heard. In fact, and it's coming from the point where we hear and we say that even God granted Adam a hearing before passing a verdict on him. That why did you do what I did? And so that's the first thing. Anytime a person is not heard, it is enough grounds to vacate a decision. But this is a criminal trial. At the moment, nobody is saying that it is not proper, because the court granted you, if you are granted the opportunity to be heard and you don't avail yourself to be heard, that's not the court's problem. But I'm saying that is what they filed an appeal, and they've raised issues. If you read the what do you call it, the submissions, you would understand what the lawyers are seeking to raise. I'm not too sure where they've gotten to now, but that's at February they filed their submissions. For me, it is a proper conviction. Nobody is saying that it's not a proper conviction, but she also has a lot of rights under the law to explore. If she decides to explore those rights, nobody should have issues with her.
So you're laying the issues bare.
That is
so
what
she should go ahead, serve the sentence, but
of course, she also
has
as we speak, he asked her whereabouts. Okay,
where is she?
She is with the police now. The spokesperson for the government has stated categorically that the police has taken custody of her and preparing her for the prison facility. She will surely be there. As a government, we do not look. Is there any evidence that yes, the former government started the extradition process? Did we in any way encumber it? We never came to say that no, because he was an appointee of President Mahama, we are seeking to hold the process. The process went on. She's been brought. The president's spokesperson or the minister for communication has stated categorically that we got him. He's with us. She's with us. We are preparing her to serve her sentence. What she does beyond what the government would do, as in putting her to in prison, what she does is her personal right, and nobody can also take that away from her. If she goes through the process, of course, why a court granted the state's plea for Mr. Dr. Akufo-Addo, if you remember, for him to open his defense in that case. He went on appeal, and the Court of Appeal quashed that decision. The same judge, her ladyship, Fiabutwe. So we are saying that there is nothing wrong with her exploring the rights under the law, but the state at the moment has a conviction, and we have to follow through to make sure she serves her sentence, and this is what we are doing. The state will never shield her. Let me emphasize, for any reason, she has to serve her sentence. If a higher court vacates this decision, that's to her advantage, and nobody can begrudge her. But at the moment, she is a convict. She has to serve her sentence, and that's exactly what the state is doing.
Minimum mamena was so heavy do ede aba awiye. Megidi say nsemu a akwatia MP waken. Ye na yate asemono ase na ebia ye nimde ebeko akwakwisi. Sisi ye no uma no besen akwakogina court. Nti asemono ebu ebo na Ghana mara eno no ebedi. But say bia mna no so Cãse ye nyan na enye His Excellency Dramani Mahama ena one influence law no, because owosa akonya no kura ye gidi say oh yes, because nobody is above the law. Mamena was na mefa wo is an answer na ebe kono meselo se winya en subscribe here. No subscribe ede ma. Like video we na share me no so unya bi envy. Comment bi la wono. Just go to the comment section. Naturally ni na for go e ma me. Meda wase. Me no ebe share me. Sisi ye ide. Macro. Bye bye.